were on the first panel that heard this. On this appeal, there's primarily two issues for consideration. There's a legal issue and there's a factual issue. The legal issue is what constitutes constructive notice under the GTLA. The controlling case for that is Hawks versus City of Westmoreland. In that case, the Supreme Court specifically held that a governmental entity was not immune from liability for failing to inspect its own property. And in fact, this court remanded this case back to the trial court to apply the holding in Hawks to the testimony from our expert concerning the City of Franklin's maintenance and inspection program. On remand, however, the trial court erroneously misinterpreted Hawks to say that it only applied to a governmental entity that failed to inspect its property for conditions that it created. The holding in Hawks, of course, is not so narrow. The holding in Hawks specifically says proof that a governmental entity failed to adequately inspect property or improvements which it owned and controlled is directly relevant to the question of whether it had constructive notice of the dangerous or defective condition resulting in injury. There is no limitation there about conditions that are created by the city or the governmental entity. It is any failure to inspect a property owned or controlled by the governmental entity. And so we get back to the question of, how does that interact with the question of constructive notice? And Hawks said that a governmental entity will be charged with constructive notice of a fact or information if the fact or information could have been discovered by reasonable diligence and the governmental entity had a duty to exercise reasonable diligence to inquire into the matter. So there's a two-part component there. The first part is really a factual question of, is the condition that's at issue in this particular case one that could be discovered through reasonable diligence? The second part is the legal question.
Counsel,
is there a duty?
On that first part, how does that get your client out of the problem or complication of, we don't know exactly when this sidewalk got as high as over a quarter of an inch, but under an inch? And aren't we in the same problem in terms of not knowing when that actually happened?
We're not. And the reason for that is this. We know from the evidence that this condition was at least about an inch or around an inch change in elevation 6 years before this incident took place. We know that from personal observation, eyewitness testimony from Barry Johnson, who is the property manager for the church, and he observed the condition of these sidewalks. That testimony was corroborated by Google Street View images that showed the condition in 2011, 2012, all the way up to the incident in 2018. It was further corroborated. I think we had 6 different witnesses that said the cause of the upheaval of the sidewalk was tree roots from an adjacent tree that had grown. Well, that tree had been dead for many, many years. It actually was cut down about 2 years before this incident. So we know the duration and the condition was fairly static from 2012 to the time of the fall. Can I say at what point, on what day, it crossed that quarter of an inch threshold to become a safety, a trip hazard? No, I can't say that. But the law doesn't require me to say that.
Can you infer that it was like that when the tree was cut down?
Well, it's not only that you infer it, it's the eyewitness testimony was that it was that way in 2012
and
before the tree was cut down.
Who cut down the tree?
The church had to cut down the tree.
The church cut down the tree. So the city didn't. So the city, I mean, if a city employee had come to cut the tree, then one could...
We'd be talking about actual notice.
Yeah, you'd be in much better shape. But nobody called when they cut the tree, you see the root problem, nobody called the city?
That was the dispute. The church employee, Barry Johnson, claimed that he did have a conversation with the city. The city employee that he claimed to have a conversation with said, I don't recall that conversation. The court resolved that conflict in favor of the city. That's why we're not here about actual notice. We're here about constructive notice. Okay. But that duration is only half of the component. The duration only tells you, okay, what is the period of time? Imagine, if you would, that this was a puddle in a grocery store, and we knew that it had been there for an hour. That information in and of itself isn't enough to put the grocery store on constructive notice. Now, if there is a duty to inspect, which there is, and the reasonable inspection would be to inspect every 30 minutes, well, now we have the other piece of the puzzle. And that's why this case was remanded to the trial court, was that duty to inspect. The trial court has misapplied Hawks and misapplied the case law and the common law to say that there is no duty on the part of a municipality to inspect its sidewalks. And that's just not legally true. Once it got remanded, then the evidence was, okay, the proper inspection procedure is not to sit passively by and wait for complaints to come in. As a matter of fact, in Lindgren versus City of Johnson City, the eastern section of this court in 2002 described the GTLA and said, basically it codifies the common law obligations of owners and occupiers of property embodied in premises liability law, which generally requires the exercise of ordinary care and diligence in maintaining the premises, including an affirmative duty to protect against dangers of which one knows or which, with reasonable care, might discover. That's the constructive notice. That's incorporated into Section 203 of the GTLA. Hawks specifically said, if you view that as not involving that inspection element, you are eliminating constructive notice from the GTLA, and that's just an absurd reading. It's not, doesn't go in line with statutory construction. So on remand, what David Johnson, our expert, testified to is that there's the American Public Works Association, the Federal Highway Administration, that have set forth the guidelines. They've set forth the standards on how a municipality is supposed to actually inspect its sidewalks. And then that inspection program has to be an active, a proactive inspection program. It can't be a passive. Now, part of any program, and this is what the trial court focused on, is part of any program certainly does include responding to complaints. If the city has actual notice of a defect, of course it has to go out and fix it. That's what is termed a spot inspection. The city of Franklin calls it a complaint-driven system.
So how often should the city inspect its sidewalks?
Exactly. So a city is a reasonable inspection policy is yearly. Yearly, these are not puddles in a grocery store. These are fairly static features within the city, and they do not change overnight like that. There is a time factor. But this is a condition, again, that the evidence showed had existed for 6 years in that dangerous state, that it was above the 1/4 of an inch trip hazard. Had the city inspected on that yearly basis, they had 6 different times to discover it. So clearly, this is one of those situations where once you put the reasonable standard with the time factor, now we can answer that question. The trial court, however, erroneously says that there is no duty to inspect. Hawks doesn't require the city to inspect, and a reasonable inspection is the spot inspection that is not an actual inspection policy. It is a sit and wait policy. As a matter of fact, the Federal Highway Administration never said that a spot inspection is the end-all be-all for inspection programs. A spot inspection was part of, not in lieu of, and that's what David Johnson testified to at trial on redirect. This case law has been developed over many years prior to the GTLA, and I understand in the footnote in the case that remanded this, it was mentioned that, well, anything that happened prior to GTLA is not applicable. Well, respectfully, under Lindgren, it says it is. It incorporated all that. The GTLA essentially is a derogation of the common law. Nothing in the GTLA eliminated the duty to inspect, and as a matter of fact, it incorporated it. As Hawks said, having a constructive notice, the only way you have constructive notice is if you have a duty to inspect. If you don't have a duty to inspect, there is no such thing as constructive notice. It just cannot be done that way. There were other, disagreements that I would raise, and we point out in our brief concerning the factual findings by the court. The main one, though, is on remand dealing with Mr. Johnson and the finding that he said that there was a reasonable inspection or a valid inspection was the kind of sit and wait, the spot inspection. And that's, respectfully, it's just not what he testified to. He acknowledged that that was part of what the Federal Highway Administration had included, but it actually went deeper than that. I can read the actual quote if the court wants. It says, every community should have more than one means of learning about problems. In addition to staff inspections, the public should be enlisted to help identify hazards and offered multiple reporting methods. Again, this is a situation where I think we had it was referenced before, the McMahon case. That was a case where you had an allegation that there were tree roots pushing up a sidewalk. That case, there were clear distinctions between what happened there and what happened in this case. The city of Cleveland in that case had actually done inspections. They had gone out prior to this incident on a periodic basis and looked for any hazards of the sidewalk. They found none. The argument that the tree root had uplifted the sidewalk in McMahon also was found not to be supported by the evidence. In this case, we specifically have evidence, 6 witnesses, some of whom were actual witnesses from the city, that said that yes, it was the tree that had uplifted the sidewalk. Now, the only relevance to that is to show the length of time that condition was there. And the only relevance to the length of time is in response to what is a reasonable inspection program. And a reasonable inspection program is that yearly inspection.
I'm going to ask this question. I think I know your answer, but let me ask anyway. There are things that only experts can testify to, and there are things that lay people can testify to because it falls within the realm of common knowledge. Where does the tree root uplifted and cracked the sidewalk fall?
I think it falls in the layperson because we all have experienced and we have observed from our own observations a tree adjacent to a sidewalk and you see a slab lifted up. We can infer from that it was the tree root that caused that. In this particular case, though, we have more than that, and I believe it may have been Doug Pratt, but it may have been one of the other city employees that said this stretch of sidewalk had several of those spots. Each one of them was adjacent to a tree. It was the city that actually said that it was the tree roots that was causing that. It wasn't just an argument that we were raising. Nobody has disputed that. As a matter of fact, there has been no evidence disputing any of the standards that were raised or any of the facts in this. Of course, they can't because they never did an inspection and never kept records about this sidewalk. Thank you.
Thank you.
Good afternoon, Your Honors. Dwayne Willis here on behalf of the appellee, City of Franklin. This, as you know, is the second appeal in this matter. It was brought down for the limited remand to look at the inspection process that was done in this case, which, as opposing counsel has pointed out, goes to the issue of constructive notice. Obviously, we would suggest that the law of the case doctrine would apply here. There was a 28-page decision by this court before where all of that proof was laid out. And in each of those elements, this court said, we haven't found constructive notice.
Well, the law of the case was it was sent back for more consideration.
It was sent back, yes, I believe for the limited consideration of inspection. And I believe, honestly, when you look at the decision by Judge McKee, what you're looking at is basically a chronological situation. There was supposed to be an offer of proof that was presented that had to do with the inspection process. The offer of proof was delayed for unknown reasons, but it didn't get in, and the court ended up ruling on the case before the offer of proof came in. So I believe, due to that chronology, the court rendered it back down for the limited purpose of putting that proof in. However, that proof has always been there. David Johnson, their alleged expert, said that in his testimony, that's the same testimony I gave in my affidavit. That's the same testimony I gave in my deposition. That's the same testimony you had at trial and the same testimony you had at the motion for summary judgment. Nothing new was presented on remand. In fact, if you look at his remand proof, the witness on remand never said the defendant had an invalid method of inspection. They have cobbled together pieces of that proof to say that a spot inspection needs something else. But he admitted in his testimony that a spot inspection is a fine way to do an inspection.
So you're saying the city had no obligation to do a periodic inspection of its sidewalks?
Yes, I am saying that. When you look at it in context of 205, the city has to determine how to allocate their resources. And this court and many other courts have said over time that that is up to them how to allocate those resources. It's a discretionary function. We don't get involved in that. We let that go where it should. When they allocate those resources to a spot inspection, which is admittedly a reactive inspection, that is a perfectly acceptable way to do that.
Well, isn't that just perhaps deciding that we'll take the risk that there are things that we should have gotten constructive notice of?
I think to an extent you could say that. If they can prove that there's something out there that existed for a certain length of time, then yes, you could.
So what I think your argument is that the city just decided to take the risk.
The city decided to allocate their resources to a spot inspection, yes, Your Honor. So
Yes.
What's the length of time? What's the length of time that they can just avoid making these inspections?
I don't know that you can put a set length of time on that, Your Honor, because it will depend on the length of time that the condition actually existed. And in this case, we don't know what that length of time is. We have an allegation from witness after witness that says it might be this, but those were factual witnesses that were ruled on by the trial court, and the trial court said, I believe these witnesses over these witnesses. And this honorable court looked at all that proof and said, we cannot say when the length of time, how long that existed for. So it could be a condition that would exist for 6 months, but that length of time might be enough if you know at the beginning of that 6 months specifically, this condition is this high specifically, and it is a dangerous condition. In that situation, having a reactive policy, they are running the risk of possibly having exposure for constructive notice. If the condition exists for 6, 7, 8, 18 years, but we have no idea in what state and for how long it existed in that state, then the spot inspection is fine. You can be reactive because you wouldn't know, and a periodic inspection wouldn't catch that. The expert, in fact, said that. He's like, with proof that I was relying on being discounted, then there's nothing here that I can say that a spot inspection or any kind of inspection would have changed the outcome. You can't say.
Counsel, I'm trying to square your no duty assertion with Hawks. And so Hawks, the Tennessee Supreme Court is directing that failure to inspect goes into the consideration as to constructive notice. So if there's no duty, what do we make of Hawks? How do we put those two things together in a way? I'm just having a hard time putting it together. Can you put it together for me here?
I can try, Your Honor, and the way I would do that is to say that Hawks is a very fact-specific case, and to me, I think Hawks is an outlier and probably should be treated as such. What happened in Hawks is a situation where without an inspection, nobody could have found that condition. Hawks's facts are in 5 ways different from the case at bar. First is the defendants themselves installed the hydrants that were defective. So you've got a caused or created argument there. Second, it was proven that the condition existed 2.5 years, not speculated that it could have been in this condition. There's no question that since they put it in there, it was defective. So you knew it was 2.5 years. That's a specific time frame. Third, the inspector testified he would have shut the valves off if they weren't working and noted the valves were closed at the time of the incident. So you not only have them doing periodic inspections in that situation, which is different from the inspection process we use, you have them saying that the inspection itself was faulty. And that's what the court relied on when they did that. They were like, there was a faulty inspection here. Had they done it correctly, they would have found it. That's why you bring in inspection into constructive notice. That also falls under the fourth issue, which is that there was a state law that they were supposed to conduct regularly, yearly flushing procedures by that law. Specific state law that required them to do something, that was an inspection. We don't have that here. And the court again in Hawks said, had they done what they were supposed to do by law, they would have found that condition. And lastly, the issue in Hawks is it's a subterranean issue to the extent that if you don't have a key and you can't open that, you can't see that valve. It's not something that's out there for the general public. You have to have that key. You have to have an ability to look at that. When Hawks says you would have to have actual notice in every situation like that unless you allow inspection for constructive notice, I 100% agree in that limited circumstance. When the only way to find it would be through an inspection, then yes, you should bring inspection into constructive notice and put that in as part of, but not all of, the length of time discussion. But again, to do otherwise with that case would take any kind of inspection that is not a periodic, specific, do this every time inspection out of the equation, which then gets us now into a swamp of, are we discussing when we have discretionary immunity for inspections, or are we taking that completely off the board? Hawks didn't do that, and I think they didn't do that because they're saying that this is a very fact-specific case. And along those lines, there's an allegation that the judge misapplied the facts of Hawks, but he did not. I mean, he recites that exactly like I've just discussed that. He says, in Hawks, the city employees during the course of routine maintenance had closed an underground valve in the feeder pipe to the fire hydrant and failed to reopen the valve after maintenance had been completed. Moreover, the city failed to inspect the completed work to determine whether the valve had to be closed for maintenance had been reopened. So the court is acknowledging the limited circumstances that Hawks applies there. It's not misapplying Hawks. It is applying Hawks perfectly to the condition that we have here. It is specifically saying that in that limited circumstance, yeah, you might want to consider that, but that's not what we have here, and the court distinguishes Hawks, and that's why the court is able to dismiss the case. I cited to several cases in my brief, Templeton, Champlin, Kirby. Those are more relevant. Those are cases where the court held that without proof that the inspection would have discovered the alleged condition, there's no evidence from which the trier of fact can remove immunity. Those cases are more on point because you have a general situation that is available to the public that can be seen, such as sidewalks. And what they found was their inspection processes were fine. They didn't have notice of it. There's no way to prove that they had notice of it. There's no way to prove length of time, and so they couldn't remove immunity. Again, looking back at the facts that we have in this case, this court, in a 28-page decision, the trial court twice has looked at the facts of those cases and said, at no point is there enough proof here to prove length of time. So what they're saying is the judge saw and heard those witnesses. As opposing counsel has pointed out, he described the factual differences between those, and he found that this witness was more credible than this witness, and that's why we don't have length of time. And again, in the order from this court, it specifically said length of time hadn't been proven either. It said, we have already concluded that Ms. Mitchell failed to prove constructive notice with the evidence before us. The court did not act inconsistently with the substantial weight of the evidence. I believe the court's decision is in line.
So, if we say that the city had a duty to inspect once a year, whatever, periodically, that's still in your concept of this case doesn't overcome the lack of proof of length of time.
Agreed. Because we can sit here and say, oh, it was there for 6 years. There was a tree that got cut down. It's tree roots that did it. I saw this section of it up this high before. But none of that is definitive proof. It was all speculative, and it was all heard by the trial court, and the trial court's like, that's not enough.
How is it speculative if somebody says the tree root did it? Nobody was that definitive?
No, I don't think so in the proof that I saw. And again, I would disagree that a lay expert can tell you that a tree root popped it up. I would argue that it would have to be an expert in trees to tell you that a tree root popped it up.
Okay.
Because otherwise, and I think the trial court got to this too when they were discussing the case. They're like, isn't there a sewer grate right there beside it, or a sewer pipe? Couldn't the sewer pipe have done it? Couldn't weather have affected it? So there are several different conditions that could get you there that would possibly cause that condition. Without an expert, we don't know for sure.
Yeah, but does it matter why the condition was caused, as long as the condition is there?
No, it doesn't matter as long as we can definitively prove how much of the condition is there.
Yeah.
We can't just say, how do we know what they're seeing isn't this much or anything at all? We don't have that proof.
Okay.
And that's what I think is required in this case. So for those reasons, I'd ask that the appeal be dismissed and that the decision of the trial court stand.
Okay. Thank you.
If I may, let me address one of those last points. I keep hearing counsel talk about we can't definitively prove. Well, that's not the standard of proof. The standard of proof is more likely than not. It's preponderance of the evidence. We have an eyewitness that said the condition was there for 6 years. We have circumstantial evidence that supports that statement. And we have absolutely no evidence whatsoever that refutes any of that. The only dispute that occurred in this case was whether or not Mr. Barry Johnson told one of the city employees, hey, you need to do something about this sidewalk. That was the only disputed testimony. Everything else was that this condition existed for that period of time. I'm glad that somebody mentioned Kirby, because Kirby versus Macon County is very illustrative of why I think there's probably the confusion by the trial court in this. So obviously under the GTLA, we have Section 203 dealing with streets and sidewalks. Section 204 deals with structures. That's what Hawks was focused on because it was dealing with that water main issue. What Kirby in 205 deals with just general negligence by a city employee or a governmental employee. Under 205, you have separate exceptions to the removal of immunity. One of those exceptions is failure to inspect. What Hawks was saying is that you do not apply 205, those exceptions to removal, under 204. And by contrast, it's virtually identical language under, in this case, 203. Kirby says the exact same thing. Kirby says 205 is a separate consideration from 203 or 204. If you have removal under 203 or removal under 204, you don't even have to look at 205. The only way a failure to inspect is going to come into play under 205 is if the building inspector went out, failed to do an inspection, found out that there was a gas leak and it blew up. The city would not be liable for that. That's 205, but this is not a 205 case, it's a 203 case. I do want to address one other thing. When Mr. Johnson was asked about the spot inspection and whether that was valid, he says, yes, that's part of it. But I went on and redirect. Did the Federal Highway Safety Administration recommend having a spot inspection in lieu of a periodic or zone inspection? His answer was, no, it did not. It was in addition to. That was a testimony, page 46 of volume 12. That's what he testified to. Now, the council wants to kind of say, no, that didn't happen, but it actually is there. It's black and white. That's exactly what he testified to. In terms of the specific state law, as I went through in the brief, there's numerous cases out there that say that a city has a duty to inspect. If it doesn't have a duty to inspect, you can't have constructive notice, and the legislature would not have put constructive notice under the GTLA if there was not a duty to inspect. That's my time. Thank you.
Thank you. Thank you both. Well presented on both sides. Thank you. Lots to think about.